and sullied by us humans, sex is a very good part of human life.
We live our lives in a great deal of hypocrisy, telling our children to do one thing while we do something else.
The quest for control. We all would love it if our lives were a bit more controllable.
Discussions within the Christian community about these questions will be primary for the survival of the Christian community.
And specifically, the question that I want to address today is one of the existence of the right to abortion under international human rights law. And the reason I picked this question is very simply, it's illustrative of several things about international human rights law that the church needs to learn. Because I find oftentimes in my battles in the legal and in the academic environment, there's a great misunderstanding of human rights. Many times when I find that I receive as much resistance within the church as I do within the secular community over the idea of human rights somehow being Christian. And in fact, the most vociferous argumentation I get occurs when I deliver talks at Christian conferences and in a Christian context. Because there is a number of issues that come up, or a widely held perception that somehow human rights have nothing to do with a biblical worldview. And nothing could be further from the truth. Specifically, when the human rights movement came into play in 1948 following the Second World War, the architects of the Universal Declaration of Human Rights were, for the most part, Christian men and women. And they borrowed heavily on the Ten Commandments in formulating their notion of what human rights are. However, in America in the 1990s, what we found is the term human rights has come to mean a number of different things to many people, none of which have anything to do with the human rights documents or the human rights documentation. For example, the Human Rights Committee is a gay and lesbian fundraising organization. And the gay and lesbian community has done an effective job of taking on the moniker of human rights for something that is not a human right. And the idea of sexual orientation is not something that is found in any of the human rights documents and cannot be defended on those documents. However, too few Christians know to ask the question, where does that right come from, and show me where you can find it in the documents. The same can be said for the right to abortion under international human rights law, because there is no right to abortion under international human rights law. Although within the academic community there have been arguments made for the fact that such a right exists, it's simply the case that it is not there. It doesn't exist, and we as Christians can use that as a way of defending the rights of the unborn in the international community. In fact, when we look at what has been going on at the Beijing and Cairo conferences on women's rights and population control, what we find is the agenda that was presented, or the group that was arguing hardest for a global right to abortion, was the United States. And that right was opposed by the Vatican as well as the Islamic countries. And in many ways, there was an anti-American backlash that assisted in keeping the status quo and not having the right to abortion being promoted as an international human right. So part of what I'm going to do with my talk today is share with you a little bit of the history, the language, the documents that you need to know, so when somebody argues that abortion is a human right, you can definitively tell them it is not. And in fact, you can use the international human rights documents in many ways to thwart the efforts to establish abortion as a human right. Now, our journey begins with the Universal Declaration of Human Rights. The document asserts that the recognition of inherent human dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. This was drafted following World War II in a climate in which the drafters were looking at the Holocaust and trying to find ways to argue that what had happened in Germany were wrong. This was in the wake of the Nuremberg trials, where they had to resort to natural law to prosecute the Nazis for the war crimes of genocide and the war crimes and crimes against humanity. And they did so on the basis of this idea that human beings have inherent human dignity. And for approximately 30 years, that document remained in force as the guiding principles of international law, to the extent that it has reached the level of customary international law, along with other documents that we're familiar with, the Magna Carta, the Declaration of Independence, and the French Declaration of the Rights of Man. And among the ideals in the Universal Declaration is the idea that every human being has inherent human dignity. Dignity, by definition, refers to the quality or state of being worthy, honored, or esteemed, and inherent human dignity in is itself a transcendent idea, which means that when it comes to arguing for the reasons that human beings are unique and have some sort of special worth to them, the only consistent logical argument begins with Genesis. We can go to Genesis 1:26 when it says he created them in his image, male and female created him them. You find that man, by virtue of being created in the image of God, has inherent worth and inherent human dignity. I have spent numerous hours arguing over the various theories of human rights, and yet when it comes right down to it, the simple statement that human beings have worth because they're created in the image of God serves as a foundational element of any human rights document and of the entire human rights movement. So if we start with that perspective, from a historical perspective, the idea that human beings have worth coming from being created in the image of God is the basis of all human rights. Now, that idea has been challenged, but not effectively so. However, we see that outside of academia and some of the proposals that were being made, particularly in Cairo and Beijing, what you found was under the guise of population control and women's rights, there was a very strong pro-abortion movement. However, what's really interesting is that when you review the scholarly writings on these two conferences, what you find is there's a great disappointment among the American academics, particularly of the feminist persuasion, because neither of these conferences produced what they wanted, which was an international right to abortion. However, the point of my paper is to illustrate what we can do as citizens if we get involved in the process. If we abandon the process, if we step out of, if we take the position that the UN eschatologically is a forerunner of the Antichrist and we shouldn't be involved with that, all we're doing is abandoning the arena and accelerating the process. We as Christians are salt, and salt is a preservative. Think about how much one person in a pagan administration can do. We look at Daniel. We look at Nehemiah. You look at Esther. There are situations in which the Lord can use a person in the proper environment or properly placed to prevent a great deal of harm. Paul, perhaps the first lawyer to appeal to the New World Order or the global community of his day, when being tried in front of the Jews, claimed jurisdiction as being a Roman citizen and took the issue to Rome, which was the global government of his time. And it may surprise you to learn that in many ways, under international human rights law, there is greater protection for your freedoms of religion than there is under American law. It will also come as probably a great surprise to realize that there is less of a right to to abortion and more protection for the unborn under international human rights documents than there is under the United States Constitution. And so before we decide to abandon the international arena, we ought to consider the fact that there is a place in the international arena, and there is language and support for the unborn that isn't found in our own Constitution, and we should be willing and able to use that to effectively defend the rights of the preborn. Let me give you a classic example of this. In 1990, one of the most prolific and prominent human rights authors, Philip Alston, authored an article called "The Unborn Child and Abortion Under the Draft Convention of the Rights of the Child." In his statement of purpose, he proposed to discuss what protection, if any, was to be found for the lives of the preborn in the existing human rights instruments, and specifically under the Draft Convention on the Rights of the Child. However, when you read the article, what you find is that his agenda was far less charitable to the unborn. And this is exactly my point. From 1990, I am not aware of any article that has specifically challenged the assertions made by Professor Alston in his article. By our silence, we have allowed this article and this contention that the rights of the unborn do not exist or are not protected under international human rights to take the field, to claim victory, because we did nothing. We did not challenge the assumption. And one of the things that provoked me to write this paper was the fact that the argument that he makes is much like the argument that we find in Julius Caesar when Mark Antony gets up during his effigy of Caesar, condemns those whom he is praising by his words through irony. Well, oftentimes what we'll find with Professor Alston's argument is the fact that his stated agenda is not neutral, and for that reason his article does far more than it intends. He begins with the conclusion that proposals to explicitly recognize the right to life of the unborn have been consistently rejected by a large margin. What he doesn't tell you is the vote was 26 to 17 with 13 extensions, hardly a wide margin. Nor was a consensus reached that there was a right to abortion. He does admit that while recognizing the fetus is deserving of appropriate protection, its right to life is not recognized, and the rights of the mother, recognized by a wide range of instruments, are fully preserved. That conclusion clearly reflects his pro-abortion bias and contradicts his stated neutrality. It also stands in contrast to the existing UN documents. An example of this is Recommendation 18E of the International Conference on Population at Cairo. The recommendation urges governments to take steps necessary to assist women in avoiding abortion, described as a measure which by no means should be pre-offered as a matter of family planning. Now, we hear the word family planning and we assume that that includes abortion here in the United States, because that's exactly what the pro-abortion movement has argued. However, under the UN documents, it's explicitly stated that family planning does not include the right to abortion. And when you read the literature, you'll find there's a great deal of wailing and gnashing of teeth from the feminist community that the right to family planning or choice, as it's identified in the international community, doesn't include the right to abortion. And what you find is, as you go through the documents, the analysis is very clear. While abortion is not prohibited, controversy and opposition has prevented an affirmative support for legalized abortion in international instruments. And that's a nice way of saying we didn't get our way. And that's the whole point. When you look at Alston's article, how he puts together the facts surrounding the Convention on the Rights of Children, he does so with a pro-abortion bias. And he tries to get the document to say something that it does not. However, if we as Christians are not savvy and are not involved in the international community, what we'll find is the document will soon come to say that, or be interpreted the way Professor Alston does, because we sit by and do nothing. History teaches us that when Christians remove themselves from the political arena, remove themselves from the educational arena, remove themselves from government, what happens? The Christian viewpoint becomes lost and forgotten, and oftentimes becomes an anathema to what is actually going on. Now, Alston, in his presentation, goes through sort of a thematic and chronological approach and begins by saying, well, first of all, you have to defeat what is said in the preamble of the document. And there's a reason for that, because when you look at the preamble, it acknowledges that the child, before birth, is a member of the human family. And in a document which reaffirms faith in the fundamental human rights and the dignity and worth of each person, the international community specifically states that the right of the child is entitled to special safeguards, including appropriate legal protection before as well as after birth. Now, Alston has to deal with that statement because it explicitly says that the child is entitled to special protection, including legal protection, before and after birth. And he starts off with a very sophisticated argument that basically says, look, a preamble is nothing more than verbiage or dicta in the front of the convention, and it's not to be viewed as law. However, the purpose of a preamble is to help you interpret the document. In other words, it's sort of the rules of explanation or the key to understanding what the document said. And so when you look, the purpose of the preamble, it's the normal place where you look for the express or explicit general statement of the treaty's objects and purposes. The Convention on the Rights of Children, then, when you look at the purpose of this document, is to do what? To protect the rights of the child before and after birth. That's certainly not a statement of promoting the right to abortion. I mean, the preamble of the document is setting forth the purpose of the document itself. Just because it's not a matter of law, it's only an affirmatory statement, is much like saying that we can ignore our Declaration of Independence when looking at the Constitution because only the Constitution is considered law. When you go through the various portions of the document, you can see that it is designed to protect the child. And one of the reasons that it is designed to protect the child is that within countries outside of the Western world, you'll find the children being used in forced labor, in child prostitution, and other situations which are gravely harmful to them. So the purpose of the document is to protect the child from those things. However, there is a great deal of debate as to how that document would apply itself here in the United States. Very specifically, I've had a number of discussions with Focus on the Family about this issue, and in discussing the Convention on the Rights of the Children, one of the things that is clear is that the document itself is not a bad document. However, the application of it here in the United States may very well have negative consequences in terms of expanding children's rights in areas which are quite dangerous. For example, the age of consent, the ability to choose friends, the ability to reject the parent's religion. And when you look at it from a particular viewpoint, such as the one that Professor Alston indicates in his article, this document can be viewed as being very anti-family. However, when you look at the document in terms of a very pro-family statement, which Article 5 talks about that the family is a fundamental unit of society and that the parents are responsible for the upbringing of the children, that is a very pro-family statement. And again, if we allow interpretations of it, such as the one Alston gives to the preamble of this document, we'll find ourselves in a position where an agenda is being fostered simply because we did nothing. Now, when we look at the history of the document, very simply, you start with the League of Nations. There was a desire to protect children in the workforce and in other areas. And as a result of this document, what you find is the Convention on the Rights of Children. When you look at the discussion of how this was phrased in the document being put together, I think you'll be very surprised that coming out of the international community, there is such a strong sense of the spiritual and such a strong sense of the right to life. For example, from the Inter-American Judicial Committee, every person has the right to life. This right includes the right to life from the moment of conception. From the Lebanese delegation, every man has the right to life and to bodily integrity from the moment of conception, regardless of his physical or mental condition. From Chile, Unborn children, incurables, imbeciles, and the insane have the right to life. From Portugal, the rights of the child prior to birth could be more clearly defined. Children must be the result of choice freely exercised by their parents. From Senegal and Malta, every human being begins from conception. And from the Holy See, the rights of the child begin before birth. Life exists from the moment of conception. Human life shall absolutely be respected and protected from that moment. Again, what you see is the committee was dealing with these various notions. Now, how the language came out is another story. And that's what Alston basically says is, look, all these viewpoints were rejected and weren't part of the document. Well, that's not quite true because, again, as we've seen in the preamble, there is that protection for the unborn. That was the compromise that was reached within the international community. The rights of the preborn were protected before and after birth by virtue of the defining statement. Then the debate goes on to how the document will be affirmed, and what you find in 1994, which is 16 years after the document was drafted, at the Cairo Conference, and this is quoting from a newspaper article, produced a historic compromise on abortion, while declaring that in no case should abortion be promoted as a method of family planning. The document also asks governments to address unsafe abortion as a health concern. Well, now, we can see that there are 2 points of attack there that we can use from the international human rights documents. One, that abortion should not be used as a method of family planning, and two, that it should be dealt with as a major public health concern. And Tom Strahan, who's going to be following me, has been doing that for the last 15 years, dealing with this issue as a health concern, dealing with the health issues as a way of attacking the abortion movement. So again, even within the UN documents, there is a sense of this that we can add on. It's another little quiver that we can add to our quiver for our attack on the abortion movement. Now, what's interesting is Alston, while he claims to be neutral, basically offers the following statement. He goes on to say that since the body of the document or the articles is legally binding, the compromise of allowing the before as well as after birth phrase to appear in the preamble was a safe one. Well, who was it? It certainly wasn't safe for the child under Alston's reading of the document. And so what we want to do when we look at the document such as this is to realize that it can be interpreted, and it's subject to the interpretation. However, if we interpret it according to the rules of the Vienna Convention on the Law of Treaties, the preamble is not meaningless. It's not just dicta that is put there in the front of the opinion. It's a way of reading what the convention is to be. Additionally, I don't know how many of you realize this, but when the argument is made that no one knows when life begins, well, at least 1/3 of the world has subscribed to a human rights document in the American Convention on Human Rights, which in its language contains the following statement. Every person has the right to have his life respected. The right shall be protected by law and in general from the moment of conception. That's in the document signed by the Latin American countries. Now, there is an argument that has been made, and it has been rejected by the courts, that because the United States is a signatory to the Organization of American States and belongs to their charter, and their charter incorporates the convention, which the United States will not sign for obvious reasons because of the statement that life begins from conception, that the United States should be bound by the document even though they haven't signed it by virtue of their membership in the OAS. Now, this was tried in an abortion case back in the 70s, and the argument failed. However, in light of the new information that we have concerning Doe versus Bolton and Roe versus Wade, that both cases were based on trumped-up facts and lies, it may well be time to revisit this issue in the international community and try to see if we can get a different ruling. Again, the point being is that there are things that can be done internationally that will benefit the pro-life movement here in the United States. Now, when we go in Alston's argument, he goes on and concludes that there is a consistent refusal of international tribunals to impinge significantly on the discretion of each state to adopt its own policy regulating access to abortion. That's hardly the right to an abortion. It simply says that the right to abortion is a matter of state law, state or national law. So therefore, what that brings the battle back to is to the national arena. It's very sad indeed that the United States is the leading proponent of an international right to abortion, while at the same time, this right is being resisted by smaller third world countries and the Vatican. And we have to realize where our friends and our allies lie. Our government is the one that is out promoting abortion, while at the same time, other countries internationally are fighting against that right being forced upon them. Now, there is no question that Mr. Alston's credentials are above reproach. There is room to question his agenda and the nature of his conclusions. Although he claims neutrality, it is obvious that he has something else in mind. Alston, whether through his ideology or pragmatism, is a proponent of abortion, whether he admits it or not. He consciously chose to publish an article on the unborn child under the draft convention to give him a forum to suggest that the great majority of international human rights instruments, although clearly recognizing the right to life, are silent on the issue of whether or not all of the protections should be accorded to the unborn child. If he can't find a right to abortion under the international documents, what he's going to find is that there is no protection for the unborn. And that's exactly my point. That point flies against what's in the preamble, but unless there is someone there to raise that issue in response, it will by default become the position of international law. And his pro-abortion bias is best seen in what he concludes the article with, when he says, legalized abortion is not necessarily inconsistent with the increasing level of protection accorded to the fetus. If abortion is not inconsistent with protection afforded the fetus within the document, then what we have there is a classic example of doublespeak. Alston, in his conclusion, might as well have been carved in stone along with war is peace, ignorance is freedom, and slavery is strength. And I think I butchered that, but in 1984, the idea that we take concepts and we change them. Language is important. How language is used is critical. And if we allow him the sleight of hand to say that the document doesn't protect the unborn, is to move a step closer to an international right to abortion. This is why we teach at Trinity Law School human rights courses to our graduates. This is why we have a Master's of Faith and Culture with a human rights emphasis. Because these arguments need to be made in the international arena and need to be defended, because we may, like Paul, find ourselves having to opt out of the U.S. court system and go into the international system to receive justice or receive a fair hearing on these issues. Just like with Alston's article, when you look at what I just quoted from that, the fact that legalized abortion is not inconsistent with increasing the level of protection accorded to the fetus, and that reflects what his true purpose of the article was. He wasn't there to defend the rights of the unborn. Essentially, he wasn't there to save them. He was there to bury them. And I mean, it was a pro-death agenda that he writes in his article, even though he was claiming neutrality. And we have to recognize that as such and deal with it for what it is, not for what he says it is. Just to say that because the right of life is controversial and should be left to the individual states to embrace or reject doesn't justify abortion. In fact, notwithstanding what Alston attempted to argue, his case falls short because the truth of the matter is that there is no right to abortion under the Convention on the Rights of Child or under any international human rights documents. And the sooner we stand up and we make that case in court and in the public forum and in the press and any place where people will listen to us, the sooner we will have another tool to use for against the pro-abortion movement. The sooner we recognize the fact that we can stand up and say that there is no right to abortion under international human rights law, is the sooner we'll be able to use that in our court system as a way of defending the unborn. If I have convinced you of anything, I hope that it is that you will be able to defend the rights of the unborn underneath the international human rights documents. And unlike Professor Alston, when we enter the arena, we don't come there to bury the preborn children, but to save them. That is our goal, that is our purpose, and we can use the international human rights documents to do that. Thank you.
We have about 10 minutes or so to take questions, so if you would walk up to one of the microphones on either side here to ask any questions. I have an introductory question. What is the best forum to find out maybe some of the best ways where we have actual text of these documents? And
You can access the international documents through the UN on the internet. However, probably the easiest way to access them is if you'll just type in the name of the document on a search on Yahoo or one of the other search engines. It's much faster to get the documents that way. And if you want the Convention on the Rights of Children, just type that in on a search and you'll come up with it. Because when you try to go through the UN documents, they have a very bizarre numbering system, and it'll take you a couple hours to find them. So that's one place that you can get them. There are a number of books out there that contain the international human rights documents, and it would be worthwhile, taking a look at a set. I know that a number of American attorneys are now making these arguments, and the sooner or the more often they're made, the more effective they will become. I know that, for example, under the Alien Tort Claims Act, in the Phil Artiga case, an argument was made that the right to be free from torture was an international human right, and a violator from Paraguay fled the country to the United States, was guilty of murdering a doctor's son, and he was prosecuted in the U.S. courts for that murder and was convicted here under the Alien Tort Claims Act because our Constitution recognizes customary international law in that sense, and one of the things that we've recognized under the Alien Tort Claims Act is the right to freedom from torture. Yes.
Thanks for the information, Winston. I was wondering if you might be able to comment if there's a relation between the International Convention on the Rights of the Child and the use of International Monetary Fund money and the use of how Planned Parenthood uses its money internationally for things like the contraceptive vaccine and others, if there's any relation between that and the international rights.
There certainly is. I mean, there is no question that a great deal of the funding for projects comes from Planned Parenthood. Let me give you an example of this. When you're in China, in Beijing, if you go to the Natural History Museum, what you'll find is a wall that lists all the people that have donated to this Natural History Museum. And right next to it, you find this wonderful display that shows, man coming out of the slime and, walking erect. And, it's sort of an anthropological view of the world that is historically inaccurate. It's been outdated for years, but yet at the same time, it's a very naturalistic view of the world. It's a very Darwinian evolutionary view of the world. But you'll find that who the largest sponsor is. And you look at the wall and you have lettering that's like this big for Carnegie and for Ford and for Rockefeller, and then you'll find Planned Parenthood in letters about this large going across as being one of the major funders of the Natural History Museum. Well, it fits in with what their agenda is. And they will use the IMF, they will use the international arena to promote their agenda. And essentially you look at the American delegation that went to Beijing and to Cairo, and you'll find a great deal of funding for the pro-abortion forces that come from grants from these various foundations. In fact, in China, interestingly enough, Concerned Women for America and a number of conservative groups couldn't get in because they were anti-abortion. And of course that flies in the face of China's one-child policy. And so again, what you found was the pro-abortion forces siding with China on that issue and being allowed in, while the conservative anti-abortion advocates were not allowed in. And I mean, does it surprise anybody that when we're talking about most favored nation status for China, the one-child policy is never discussed? Again, I don't have the documentation with me, but in another paper I did, there's evidence that, for example, the fetuses are being sold to restaurants to be used as a delicacy in China. And the medical profession there is participating in that. And in fact, the author of the article was horrified when one of the doctors offered him as a gift a fetus to be used for food. And this is what's going on, and this is why people are afraid of the international agenda, but this is the type of thing that if we're involved in the international arena, we can expose and we can show that this is not what international law is about. This is an agenda that's being fostered through international law.
Are there any, does Trinity or yourself, or is there any coherent plan to deal with the next International UN Conference, or currently to try to alter the International Monetary Fund agendas?
We are dealing with it in the sense of educating people to understand the arena, and then training people to enter the arena and deal with that. It's really right now, as we've had in our public policy discussions, there's a great deal of talk of how to do this, but there isn't a great deal of organization. So right now we're educating the people to get involved, to try to affect policy in that. One of the ways you can get involved is write your senator, write your congressman, be aware of the issues and follow them. I mean, they are out there. If the UN publishes a lot of documents. The thing is, you have to read them, because a lot of what is being said is being interpreted or is being given a spin. And when you read the documents, just like with Alston, when he read the Convention on the Rights of the Child, he completely ignored the preamble and took a document that says in the preamble that the rights of the child are protected, and said what? That the Convention promotes the right to abortion, which is exactly what it didn't say, but yet nobody challenges him on that. And until we as Christians, doctors, lawyers, officials understand and work with the documents and are able to counter these arguments, people are going to accept this as being the truth.